Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 in Jefferson County, Texas. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into two categories. It's either felony or misdemeanor. Your felony cases are what we refer to as your most serious type offenses. And when I talk about, or when I use the term serious, what I'm talking about is the fact that I'm talking about the nature of the offense and the possible punishment range. Now, your misdemeanor cases are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they're not serious as a felony case. Now, if you had a felony case, it would fall into one of five categories. And we'll start at the top. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you were convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine that does not exceed $10,000. If you were convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years, and a fine up to $10,000. If you're convicted of a first-degree felony, range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine up to $10,000. Now, the highest felony, as I mentioned earlier, we start at the top, is the capital murder. Now, if you're convicted of a capital murder, the range of punishment is life without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because your offense is a misdemeanor. Misdemeanors are divided into three categories. We'll start at the top. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, your range of punishment is by fine only. Now, your Class C misdemeanors are cases that are normally handled in the city court or the JP court, and then they are appealed up to this court, and the punishment range is the same. It's by fine only. Normally, the fine usually does not exceed $500. Now, if you are convicted of a Class B misdemeanor range of punishment is 0 days to a maximum of 180 days in the county jail, and a fine that does not exceed $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum 365 days in the county jail, which is a year, and a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that we're going to talk about, or the first right that we're going to talk about, is your right to have a trial. Well, your right to have an attorney. Now, the paperwork that you've been handed out on that clipboard, it talks about your right to have an attorney. And we're going to go over that paperwork with you. On that first page, it states, judge's explanation of rights of defendants without an attorney. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you can represent yourself. Now, you can represent yourself if you waive your right to have an attorney, which means if you give up your right to have an attorney, then you can represent yourself. Now, that document also says that if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given a different court date or another court date from today to give you time to hire your attorney. If you want an attorney and do not have the money to hire an attorney, then you will need to fill out a financial questionnaire. Now, the financial questionnaire is a document on your clipboard that is titled is titled Jefferson County Affidavit of Indigence. It should be maybe the third page on there. It has some financial information on it. You have to fill that information out so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney, which means give up your right to attorney and represent yourself, then you'll have an opportunity to talk to the prosecutor. Now, the prosecutor is the district attorney or the assistant district attorney that's handling the case, works for the Jefferson County District Attorney's Office. You can talk to that person. However, you may not speak to the prosecutor about your case unless you first sign a waiver of counsel, waiving your right to an attorney. That waiver of counsel is the second page on that clipboard that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, and employment. Now, if you choose to waive your right to have an attorney or give up your right to have an attorney, you may change your mind at any time and request that the court-appointed attorney to represent you. Now, at the bottom of that document, it states defendant's choice. It's in bold letters. Make only one choice. Now, if your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you already have an attorney appointed to represent you in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to have an attorney or give up your right to have an attorney and represent yourself, well, you'll place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines at the bottom of that document, then you will sign your name on the line that is titled defendant. And you will date it today's date, and today's date is October 10th of 2023. You're going to date it today's date on the line that's titled date. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to read and sign the next document. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. That means that you're doing this of your own free will and nobody's forcing you to do it. And it also says that, and intelligently made. Intelligently means that you know what you're doing. So nobody's forcing you to do it, and you know what you're doing when you sign this waiver. Furthermore, I have been advised this 10th day of October of 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to afford counsel or to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, October 10th of 2023. Now, as a defendant in a criminal case, you also have other rights. One other right that you have, the second right that I'm going to go over is your right to have a jury trial. When those young people are sitting in that jury box, we call that the jury box. And the jury sits in that area and they will listen to all of the evidence in your case. They will listen to the arguments of the attorneys and they will deliberate, and then they will decide whether to find you not guilty or guilty of your charges. You also have a right to waive or give up your right to have a jury trial. That means you're waiving, which means you're giving up your right to have a jury trial. You will not have a jury trial. You have a right to do that. Now, if you waive or give a right to have a jury trial, then your case will come before the court in one of three ways. One way it will come before the court is by way of a bench trial. A bench trial means that you don't have a jury, but you have a judge only who will listen to the evidence, listen to the arguments, and then the judge will decide whether to find you not guilty or guilty. The other way that your case will come before the court is by way of an agreed plea bargain. An agreed plea bargain means that you in the state or you in the district attorney's office has reached an agreement to settle your case. Now, if you reach an agreement to settle your case, we call that an agreed plea bargain. That agreed plea bargain will come before the court, and then the court can either accept or reject the plea bargain agreement. Now, if the court accepts the plea bargain agreement, if you decide that, well, you think that you might have been wrongfully convicted or the court committed an error by convicting you, and you would like to have a higher court to review your case by appealing, then you have to get permission from the judge to appeal your case to the higher court. Now, that higher court that I'm talking about is located, ironically, right above us on the third floor, and it's called the Ninth Court of Appeals. You'd have to file an appeal, and they can either grant or deny your appeal. If they grant your appeal, then they could just simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. Or they can just simply deny your appeal. Now, if they deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. That court that you will be appealing it to is the Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means that you'll be representing yourself. You will not be having an attorney assisting you to file this document. You'll be handling this or filing this document on your own. Now, they can do one or two things. They can deny your petition or they can grant your petition. If they grant your petition, then they can order the case to be sent. They can simply find you not guilty. That's one thing. Or they can send the case to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a new trial. Or if they deny your pro se petition, then at that point, your conviction will stand. Now, the third right that you have a right to have what is called an unagreed plea bargain agreement. That's the third way your case will come before the judge if you waive your right to have a trial, and if you do not have a bench trial, and if you do not have an agreed plea bargain agreement. And an unagreed plea bargain is basically states that you and the state have not been able to reach an agreement to settle your case, and therefore you want the judge to assess the punishment or to give you punishment in this case. And the case will come before the judge, and the judge can assess punishment anywhere within the punishment range of your offense. Now, you also have a right to have witnesses to come to court. That chair that's behind that microphone is called the witness stand. And what witnesses do, they can testify either for you or against you. Now, as if you're represented by an attorney or if you're representing yourself, you can ask them questions. Your attorney can ask questions if they're representing you. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court to testify. Now, if you waive your right to have witnesses testify, that does not mean that the state will not be calling witnesses. They will be calling witnesses to testify in the case that they have against you. Now, you also have a Fifth Amendment right against self-incrimination. Fifth Amendment right against self-incrimination means that you have a right not to testify in your trial. State of Texas, the DA's office, the government cannot force you to testify in your case. However, you can waive or give up your right, and by doing so, you'll be testifying in your case. Now, you also have a right to have what we call discovery. Now, discovery just basically means you have a right to see the evidence or discover what's in the state's file. For example, you have a right to see witness statements, your statements, police reports, lab reports, documents, audio. You have a right to listen to audio recordings, see video recordings, any instruments that they have, or whatever evidence that the state has that they'll be using against you in your case. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. And by doing so, you will not have access to the evidence that the state has against you. Now, everyone here that's for a case you've been arrested, that is, went to jail, you've been arrested, and you out on bond, you either out on a cash bond, which means you paid the full amount of the cash to get out of jail. You out on surety bond, which means that you paid a bondsman a percentage of the cash to get out of jail, or you're out on a PR or a personal recognizance bond. That means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance, promising to appear in court, and you are here in court. So every day that you spent in jail, that can be used as credit towards your punishment. So, for example, if you spent 5 days in jail, the state is offering you a plea bargain of 5 days in jail. That means that you would not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Now, if they offered 7 days in jail, you spent 5 days in jail. That means you would only have to serve 2 days in jail because you'd still be given credit for the 5. The 5 will be taken from the 7, and it leaves 2. Now, every day that you spent in jail, $100, you get credit at $100 a day that will go towards your fine and court costs. So if the state is offering you $500 fine and court costs, and you spent 5 days in jail, that means you don't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Now, if they're offering fine and court costs of $700, you spend 5 days in jail, that means you won't have to pay $200 because you have credit for $500, which will be taken away from the 7, which leaves $200 balance. Now, you'll be required to pay the balance on the day that you dispose of your case. However, if you cannot pay the $200 in this example, on the day that you enter your plea, then the court can put you on what is called a payment plan. You can pay it off in small monthly installments until it's paid off. Now, some of you may not have the ability to even pay it off, even we'll put you on a payment plan. Well, that's not a problem either, because the court can convert your fine and court costs to community service. And every 1 hour of community service that you perform at a nonprofit organization in Jefferson County, you will receive $12.50 that will go toward your fine and court costs. So, for example, if you work 8 hours of community service in one day, that's $100 that will go toward your fine and court costs. So an example that I gave earlier, a $200 balance, you work 2 8-hour days at a nonprofit organization, that's $200, and then it'll be paid off. Okay. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is for first-time offenders. So if you haven't been in trouble before, first time getting into trouble, they have a program in pretrial diversion. What they will do, when I say they, I'm talking about the district attorney's office, because it is the district attorney's office program. They will dismiss your case. And if you complete the program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off from your record. Now, in order to qualify for the program, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. You have to have an attorney to get you in the program. And then the other thing is, as I mentioned earlier, the other thing is you cannot have any previous offenses, okay? You have to have an attorney to assist you getting in it, can't be a pre-offense, and it cannot be unlawful carrying a weapon or resisting arrest. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program, which is part of the pretrial diversion program, that is called Veterans Court. Now, Veterans Court is a program for veterans only. And what they'll do in that program, if you get into the program, and you complete the program, then they will, you can qualify for what is called a non-disclosure. And what a non-disclosure is, it means that the state or we cannot disclose the fact that you are on deferred adjudication to the general public. So the general public cannot have access to it. However, most governmental agencies can, like the police department, colleges, and some of these other government agencies. But generally, the general public cannot have access to it. Now, again, if you're interested in any one of those programs, just let us know. We have some prosecutors here who will come out and they can tell you more about the program and they can get you started and getting into that program. Now, we also have some individuals here from Spindletop. Spindletop is our local mental health agency. We have a program that is called the CSI programs. That's a program that I started within the first 100 days of taking office in March of 2017. With that program, we have a partnership with agencies in our community. One of the agencies that we have a partnership with is Spindletop. Spindletop, they have some individuals here who's from Spindletop. They're going to come before you and tell you a little bit more about that program. But generally, what the program is designed to allow them to interview individuals, do assessments, and develop a treatment plan. Now, with that program, a person does not have to be incompetent or insane. A person could be suffering from depression, anxiety, or any other host of mental illnesses. They'll be able to address that for you. The other thing is, Spindletop also has a program for this called ATAR. ATAR stands for alcohol. It's a treatment program. And with that treatment program, it's the alcohol and treatment and recovery program. Well, with that program, if individuals have problems with alcohol or drugs, then they can provide a screening, they can do an assessment, and they can provide a treatment plan to address your issues that you may have with drugs and alcohol, either through outpatient or inpatient services. And OZAR, the local Drug and Alcohol Council, has a program that's called OZAR, stands for Outreach, Screening, and Recovery. They also have a program that does this. It's similar. It does the same thing where they do screening and assessment, and they'll refer you to a program to address your issues. Now, if you're unemployed, do not have a job, or if you're looking for a better job, we have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. With that program, they will not only train you in the area that you select, but they will also assist you at getting a job in the area that you're trained in. If you have not finished high school and you like to get your GED, your graduate equivalency diploma, then CICE has a program for individuals who like to get their GED. Now, these programs that I just mentioned to you are part of our CSI program. And in this program, if you want to get into any of these programs, it doesn't cost you anything. They're free. It just costs you some time. And in this court, we like to say we don't just give time. We take out time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I always like to say that when you come to county court at county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their lives, then we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in our community. Why? Because what comes out of the home goes into the community. And so these are the programs that we have here in county court at law number 2. If you're interested in any one of these programs, they're free. we'll be happy to assist you. Now, at this time, as I mentioned earlier, we have personnel from Spindletop. They're going to come forward and tell you something about the program that Spindletop has to offer. This is a successful program that Spindletop has, and they're going to tell you about this program. At this time, we have Deputy Hinton and Gabby, who's going to come and tell you more about that program.
Thank you, Ryan.
You are.
Good morning. My name is Steve, and I'm a mental health deputy licensed by the state commission here with the sheriff's office. I'm here with Ms. Gabby. Now, Gabby is a qualified mental health professional at Spindletop. And the reason we are both here this morning is because the judge has invited us to this courtroom because he cares about every single person that comes before the bench. What the judge has found, or statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just the lack of community resources to help you with your particular situation.
So what we mean by mental health, we mean stuff that's common for almost everybody, depression, sadness, or just anxiety that the court system doesn't get involved with. And also, the lack of basic needs being met doesn't help with anxious. Talking about basic needs, we mean housing, food, employment, possibly food classes, getting this support. It doesn't help being in here because this kind of exacerbates the sense of
Maybe this is your first time to be here, maybe it's your 10th time to be here. You still hope. What we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us. And when you first came in, Gabby handed out these documents to you, and we're going to use those as a way to find out how we can best serve you. We're not here to embarrass anyone. This is very private. This is not a court document. The only ones who can see this outside of permission is only us, so we can find out how to serve you. But she's going to tell you exactly what you can do to share that need with us so we can see how to best help you.
So two things that I really need so I can contact you would be a good phone number for me. And with this phone number, I will be texting y'all individually from my work phone. The only person who will help me is me. And so the initial contact will be through text message. If you can't receive text messages, let me know. And we can work with that. But if you'd like to call later on, you can schedule a call out. I don't want to interrupt your work day or your day that you're having. And so we can schedule that works best for you. And the second one is, you see it says resource requested. All you have to do is check a box which one that most that you would need. And if you want to do another resource that's not on here, you can put it right there. And also, if you would like to talk today with this, go in the back and talk, there is something along here, you can check it if you want.
I also have this flyer that I want to give each and every one who's here. It tells you a little bit about the advantages of participating, but also in front, it has a 1-800 number. If you ever find yourself in an unsafe place, you can call that number immediately. And just shortly, the court is going to go into recess. And when it does, we'll be coming out there with a form from y'all and the student as well. And we'll be able to visit that. Thank you very much.
Thank you.
Thank you, Deputy. Thank you, Deputy Hinton and Gabby. Ladies and gentlemen, the paperwork that you have in your hand, if you need any assistance in filling it out, we have our court personnel who is here that will be happy to assist you at filling the paperwork out. Now, once you fill the paperwork out, then we will pick the paperwork up from you. And then we're going to ask, once we evaluate the paperwork, we're going to call your name one at a time to come up before the bench. And that's going to take us a little time to go through the paperwork and then to call you up one at a time. But in the meantime, if anyone needs to use the restroom, there are 2 restrooms right outside the courtroom. The men's restroom is in front of County Court at Law number 3, which is right next door to us. And right across the hall from County Court at Law number 3 is the 172nd District Court. That's where the women's restroom is. Now, if you, again, need to use the restroom, you can go out in the hall, use the restroom. Please do not leave the courthouse, because if you leave the courthouse and if you call your name and you're not here, your bond will be forfeited. And if your bond is forfeited, warrant will issue for your arrest, you'll be arrested and placed in the Jefferson County Jail. Okay. So at this time, the court is going to go in recess. If anyone needs any assistance, just please raise your hand. And, okay, please raise your hand and we'll have someone to go out and help you with filling out the paperwork. All right. And the court is in recess?
All right.
No.